So, seeing that we have quorum, I'll call this meeting to order. We have no public meeting tonight. We do have, in fact, two recommends and one discussion item on our agenda tonight. The first item is 203-205 Colborne Street, and this comes with a recommendation in front of us. If I can ask staff to... Oh, you're right. I want to rush right through. We need to approve an agenda. So if there's a mover, thank you, Councillor Sanik. Thank you, Councillor Hill. And there is an addendum, which is a letter that we just received. So everybody should have a copy of that as well. So approval of the agenda with the addendum. All those in favor? Carried. And we have two confirmations of minutes. I think we've all received those. That the minutes from January 10th, Planning Committee meeting, be confirmed. Yeah, if there's a mover. Thank you, Councillor Sanik. Thank you, Councillor Kiley. All those in favor? Carried. Disclosure of pecuniary interest. Yes.
Corporation of the City of Kingston, declare my pecuniary interest in the matter of report number D14-195-2010, as I own a property that I rent out to a Queen student that's directly adjacent to the Colborne Street property being discussed.
Thank you. And the clerk has that? Perfect. Delegations, seeing none. Briefings, seeing none. Business. Our first business item, the portion of this meeting is open to the public. The city has initiated a new process in which members of the public will have the opportunity to speak for up to 5 minutes on comprehensive reports presented before the Planning Committee. Those wishing to provide oral comments at this meeting will be invited to do so. If a person or public body of the City of Kingston if a person or public body would otherwise have an ability to appeal the decision of the Council of the Corporation of the City of Kingston to the local planning appeal tribunal, but the person or public body does not make oral submissions at a public meeting or make written submissions to the City of Kingston before the bylaw is passed, the person or public body is not entitled to appeal. And now we'll get on to our first item, which is 203-205 Colborne Street. Thank you.
Good evening, Mr. Chair, members of Planning Committee, members of the public, as well as staff. My name's Lindsay Lambert, and I'm a planner with the City's Planning Division. This evening, I'm here to present the staff recommendation of approval for an application for zoning bylaw amendment for 203-205 Colborne Street. Before I get started, I'd just like to mention that the property owner, Mr. Patry, is here this evening and has indicated that, if need be, he can answer some questions when we get to that point of the consideration of the recommendation. So the purpose of the application is to amend the existing B3 3 to 6 family dwelling zone to a special B3 561 zone in zoning bylaw 8499 to permit the existing building on the property with a total of 5 dwelling units. There was a previous comprehensive report prepared in September of 2018. However, that report was withdrawn at that meeting as additional information was received and staff undertook a further review and refined the recommended zoning. The application was submitted quite some time ago in 2010 in response to zoning enforcement on the property. What rendered the property to be non-compliant with respect to zoning was not the land use. 5 units is currently permitted within the zone that applies to the property. However, it was some of the performance standards within the zone or zoning bylaw, such as vehicular parking. So in terms of a decision date, one was required back in 2012 based on the city's date of receipt of complete application. Further, in terms of application history, there were 2 previous minor variances approved for the property in 1990 and 1992, as well as a 2010 minor variance application, which was denied by the committee at that time, which resulted in the current zoning application being filed. In terms of zoning enforcement, the owner has a couple of options in terms of removing the additional unit to render the property compliant with the zoning, or to file a Planning Act application for zoning bylaw amendment to achieve a zone that fits with the built form and performance standards that are on the property. 2 statutory public meetings have been held for this file, one on March 1st, 2012, and the second on August 29th, 2017. Staff can confirm that all notices have been provided on this application in accordance with the Planning Act, including a notice of regular meeting, which was sent at least 20 days in advance of the meeting this evening. This slide provides an indication of the location of the property. It's on the north side of Colborne Street, just 1 block north of Princess Street, between Chatham Street to the west and Division Street to the east. The area contains a mix of densities and built form. The property is immediately adjacent to apartment buildings and other multi-unit buildings ranging from 2 to 4 stories. This is a site photo showing the north elevation of the existing building. In terms of the official plan, based on the time of the filing of the application has been reviewed under the 2010 official plan. The property is designated residential, and the proposed or existing density is 77 units per hectare, which is just over the threshold of high density land uses considered in the official plan. Although it's important to note that within the existing zone of the property, it currently permits 123 dwelling units per hectare, and therefore the application doesn't require zoning relief with respect to density. Just a map showing the existing zone and the zone surrounding the property, the B3 zone. This is a slide of the submitted site plan that staff received with the application. It shows the existing building footprint, the 3 proposed vehicular parking spaces at the rear, including 1 barrier-free parking space, an existing shed at the top left-hand corner, which is proposed to be removed, and a pedestrian walkway through the continuous depth of the property from Colborne Street all the way through to the back. The property doesn't have vehicular access via Colborne Street, and therefore the applicant had filed a consent application seeking approval of an easement from the property to the north, which is indicated on this site plan, to provide an easement for vehicular access for the Colborne Street property via Elm Street. That application was provisionally approved by the Planning Department in September, and the applicant has a year to fulfill the conditions of that provisional approval. This slide shows the existing building elevations of the property. What's been noted through the review of the application is that the building does require some upgrades in terms of OBC conformance. Those would be, in summary, just to replace an existing rear elevation window with an exit door for Unit 5, install a new 1-hour fire shutter window on the rear elevation, Unit 5. On the second floor, to install a new 1-hour fire shutter window on the rear elevation for Unit 4. Add a new stair to attic level 4, and then on the third floor, add a new stair with landing for attic bedroom. Add a new dormer on the west elevation. And I'll note that the Chief Building Official, Lisa Kapner-Hunt, is here this evening to speak to the OBC aspects of the development. The applicant has indicated that the intended time to complete the works would be from May of this year through August. And so from my understanding is that from the time of the issuance of a building permit, the applicant has 6 months to commence the works. This is a chart, a matrix of the existing zoning requirements of the B3 zone, what's proposed for the existing development at 205 Colborne Street, and an indication on the right-hand column as to what relief the application requires. If it's hard to see, this matrix could be found on pages 18 to 22 of the staff report. So in summary of that, in terms of zoning provisions that the development complies with currently, on the left-hand side, the 5 units are permitted within the existing parent zone that applies to the property. The property is compliant in terms of density. Landscaped open space, which is a newly introduced zoning provision of 30% of the lot. Bicycle parking is being provided in accordance with the bylaw requirements, as is barrier-free parking. And of note, when the application was initially filed, the development was not compliant with amenity area. However, those requirements have been changed, updated comprehensively through the city through the amenity study area review. And the property has now been reviewed to be compliant with the minimum amenity area requirements for the 5 units on the site. So in terms of the zoning relief that staff have included in the recommended zoning bylaw amendment for your consideration this evening, vehicular parking, the current bylaw standard is 1.4 parking spaces per unit. The applicant did provide a parking study that has been reviewed to the satisfaction of our technical group. And so, as shown on the site plan, the applicant's proposing 3 parking spaces, which is roughly a 0.6 parking space per unit ratio. Lot occupancy, which is a function of the calculation of all the gross floor area of the property in terms of the size of the lot in which it sits on. The current bylaw requirement is a maximum of 100%, and the recommended relief for the current building footprint is 111%. Staff are also including relief in terms of permitting a portion of a dwelling unit to be located in what's considered a cellar in the bylaw, and that's something that has been processed through other applications, given that the OBC can address that matter. There's been some relief in terms of existing projections of balconies, stairs, and stair landings, which is fairly minor in nature. And then to provide flexibility for the possibility of bicycle parking being located within the building, the minimum width for a bicycle parking space has been recommended for some zoning relief. So this is the Schedule A, the mapping portion of the zoning bylaw amendment that's part of the agenda package. recommending that the property be rezoned from the B3 zone to the B3 561 zone. And then because of the unique nature of the site, given that the main portion of the building on the site predates the zoning bylaw, staff have included some provisions to afford the property with a recognition of legal non-complying status for that portion. And then have in turn included some provisions for building B, which is the black portion at the back, which basically permits that portion of the built form to stay on the property, but any expansion in the future, the expectation within the recommended zoning provisions is that the property would have to comply with the applicable parent provisions in place at that time. So throughout the application review, 4 pieces of correspondence have been received to date, and we did receive some input through the 2 previous public meetings on this application. And this is a listing of the general themes of concerns that the public had expressed with the application. So in terms of amenity space, as I had indicated, the application is now compliant, or the property is now compliant with the city standards on minimum amenity space. In terms of parking, the concern was that perhaps it was suggestive of the fact that there may be too many bedrooms in terms of the actual provision of parking. However, the bylaw standard that staff work with does not base the parking requirements on a per bedroom basis, it's on a per unit basis. And the staff conclusion on review of the parking study was that the proposed ratio was appropriate for the property and its location, in terms of it being a highly walkable area and there being proximity to 2 routes of express transit on Division Street as well as Princess Street. Servicing capacity, Utilities Kingston has reviewed the application and has cited no concerns with respect to servicing capacity. Density, the property is compliant with density as far as the B3 zone is concerned. In terms of lot occupancy, staff have reviewed the built form present on the property in relation to the built fabric within the wider neighborhood, and feel that it's a minor amount of relief, and the property is consistent with the other built form in the neighborhood. Unit composition, in terms of the number of bedrooms within the development, that's something that's not regulated through our zoning bylaw, and our performance standards of the zone are on a per unit basis. There was a concern with respect to the zoning enforcement aspect of the file, and as staff have confirmed, the applicant is, while it's taken a long time to process the application to this point, the applicant has pursued one of the avenues to remedy the situation. And there was a concern about the permanence of the access easement, and the way that is addressed is that the easement and the right-of-way is actually registered on title, and so it provides for that in perpetuity. So in terms of the staff recommendation, the proposed development is appropriate and adds to the range of built form and dwelling unit sizes available in the area. It contributes to increasing the total residential density within the urban boundary. The proposed amendment complies with the PPS, the Provincial Policy Statement, the official plan, and constitutes good land use planning, and staff recommend approval of the application. In terms of next steps, should the application be approved, the applicant is required to obtain approval under site plan control and final approval of the consent application to secure that vehicular access for the site.
Thank you. Thank you very much. I will turn to the committee now if there are any questions, or and then we'll go to the public for public input, and then we'll come back and move the recommendation, and committee will have more time to ask questions at that time if anything comes up. Are there any? Yes, Councillor Chappelle.
Through Mr. Chair, question is regarding parking. Is this area known to have proliferation of parking problems? Because I noticed that the site reduction would be going from 7 to 3. If you could just comment on the parking.
As through you, Mr. Chair, as I had indicated, it is a highly walkable area. There is a north-south as well as an east-west express transit route available within the property. A 0.6 parking ratio in this area is certainly not unheard of. Larger developments along the Princess Street corridor, which is just a block away, are being there are parking studies being approved through those developments for ratios of 0.5. And so staff feel that it is appropriate given the area.
Great, thank you very much. Seeing no further questions, we've lost our vice chair. I'm going to ask Councillor Sanik if she'll take the chair.
Chair, and recognize you.
I just have a couple of very quick questions. I do know that there was a report from Planner Tim Fisher in 2010 that stated that in the opinion of Planning and Development, it was not, the proposal was not in keeping with the purpose of the City of Kingston official plan, and a further comment was that it was in non-compliance with the existing zoning. Will this proposal bring this into compliance with both those aspects of our both our OP and our zoning?
Thank you, Mr. Chair. In terms of the official plan, staff have undertaken a thorough review of the OP policies that are applicable to this development. They're presented in the staff report. Staff have looked at the existing built fabric of the property, have very tightly crafted the zoning bylaw to insert requirements that going forward, should changes be made in terms of that rear addition, the property is then required to comply with the parent zone, and so staff feel that that's an important provision to have included. The relief that the development has required has morphed over time and has lessened. In terms of amenity space, it's a significant change, and staff are quite pleased that the property is able to comply with both the landscaped open space, which is a new requirement of 30%, as well as the minimum 18.5 square meters per dwelling unit for the property. In summary, in terms of adverse effects, that's an existing situation. As I said, there are provisions crafted in there to have the portion of the property to return to the parent zone applicable. All of the relief that staff have included in the bylaw would render it completely compliant with the current standards, and
Great.
Staff are happy with the recommendation.
Thank you. I have a question that's probably for our building person. I know one of the frustrations in the community has to do with a decade of it being in non-compliance. Will it be in full compliance on completion from a building code perspective? And is there basement occupancy? And if so, are ceiling heights and all of that going to be in full compliance with the Ontario Building Code?
Through you, Mr. Chair. Yes, I say that. I'm not sure. Yes, so a building permit will be required for the completion of the units. They will be inspected. All life safety requirements under the building code will have to be adhered to, as well as an occupancy permit issued for the project.
And share Councillor Chappelle's concern about parking. I know that this is in compliance with our, I would say, somewhat outdated rules about parking, 1 per unit, but it is in compliance. But the question I had was, part of the issue in that downtown, in the downtown core, is that sometimes we grant an application because of an amenity space, and then the amenity space, and I'm not accusing this developer of doing that, but in some other developments, that amenity space becomes parking shortly after completion. How can we be vigilant? How can we make sure that that doesn't occur again?
Through you, Mr. Chair, the application will be, or the building will be subject to site plan approval. So through that application, we actually dictate where the location of the parking spaces are on the property versus the location of the landscaped open space. So we do have the ability to regulate exactly that, and it gets registered against the title to the property. So we do have the ability to enforce on any changes that don't conform with the site plan agreement.
Thank you very much. And there's one other question that just escaped me, but I'll bring it up when we get back into the committee recommendation.
Those are questions I'll return the chair to.
Thank you very much. So I will now open it. Oh, did you have a question? Sorry, Councillor Hutchison.
Couple of questions. So my report, and perhaps you can just tell me, so is this property currently legal? It seems that it's saying it's illegal.
Through you, Mr. Chair, yes, some of the zoning performance standards of the B3 zone are considered non-compliant, but in terms of the use is permitted.
Right. So how long has that been the case?
Through you, Mr. Chair, it's acknowledged that around the time of the application filing was when the information was brought forward to staff.
Does that mean it's been illegal it's before 2010?
It's hard for me to pinpoint time frame, but it was around 2010 when it was brought to staff's attention.
Okay, well, I've got to ask later. I got a policy question about that. So it also indicates in here that that I think it was 3, but when some of the units are in the cellar, in cellar space, and that's not normally allowed. I know that. So why is it being allowed in this application?
Through you, Mr. Chair, it's been a long-standing provision from zoning bylaw 8499, which dates back to the 1970s. There have been changes to the building code, as I understand it, and so this committee has seen quite a few amendments to remove that prohibition from site-specific developments.
Well, that's the case under certain criteria. The question is, does this particular application meet those criteria?
If your question's more of a building code nature.
Thank you.
Thank you, and through you. Yes, in terms of what Ms. Lambert was saying, there has been a long tradition of looking at being allowed to have second units or additional units that are in the basement of dwellings, and there's specific provisions for that. Specifically from a building code perspective, it really has to do with the percentage above ground in windows and light. Are you saying no? I'm sorry, perhaps our CBO should answer that question, but there are provisions that are related to regulating to make sure there's adequate daylight, ventilation, all of those types of things about having units that are subgrade, and those have been reviewed as part of the application.
Okay, I don't think that answers the question, which was, why is it allowed in this instance?
Can you repeat the question?
Question was that normally dwellings are not allowed in cellars. And I know that sometimes there were some changes some years ago. But in this case, it's been identified. And then the answer there talked about certain criteria being met. So I'm just wondering why, in this particular instance, this application, why dwelling in a cellar is being allowed?
Through you, Mr. Chair, we've reviewed the application, and in conjunction with the building department, we're satisfied that from a habitation perspective, allowing dwelling units in the cellar of this building is appropriate. They will be required to comply with all of the requirements of the Ontario Building Code, which we're satisfied from a planning perspective with the rationale for having that prohibition in the zoning bylaw in the first place. I would also like to note that through the second residential unit provisions that we're going to be bringing forward to Planning Committee in the next couple of months, staff will be proposing to outright remove the prohibition of the habitation space within the cellar from the zoning bylaw altogether across the city.
Okay, well, I guess we'll have to wait for that. One of my other questions is the amenity space. How is the amenity space constituted on this site? Like, what are you adding up to get to amenity space? I believe the amenities is also less than was normally required. So what I'd like to know is how do you constitute the amenity space?
Through you, Mr. Chair, there was a change to the bylaw requirements across the city in roughly 2016, I believe, amending the minimum requirement for amenity space to, for this particular area, 18.5 square meters per dwelling unit. In terms of the makeup of the proposed amenity space, it's been found to be compliant with the total amount required as a minimum. And that space can be made up of private outdoor amenity space, such as balconies, which forms part of how the applicant is achieving compliance, as well as some communal amenity space at the rear of the property.
Just for the committee,
Yes, Ms. Agnew.
there is a description on page 20 of the report that talks specifically about the types of amenity space that are proposed based on the building, the way that it is, looking at the private versus the more communal space, and it's broken down in detail.
Thank you. Any further question? Or?
Not this one.
Thank you. So, seeing no further questions, I'll open it up to the public. Just identify yourself with your address, if you would. And just a reminder that you have 5 minutes.
Okay, Frank Dixon, 495 Alfred, apartment 2, K7K 4J4. Thank you, Mr. Chair. Thank you to Ms. Lambert for excellent presentation and thorough report. I've been following the file on this, and I'm happy to see that enormous progress is evidently being made. It's taken a lot of work by staff on this, I know, and the committee has been paying attention to it, so that's very good. I have some comments and suggestions. Number one is I'm wondering if perhaps some off-site parking could be offered on the parking shortfall aspect by the landlord. So that's just a question. Has that been discussed? I know it's a fairly densely populated part of town. Okay, number two is we're now into winter, and things like sidewalks and so forth being slippery, snow removal, that kind of thing is a safety aspect for all of us. And I'm wondering if maybe that has been looked into in some detail. Given that the property is fairly compact, getting in and out is a challenge, just by the way it's been adapted. Okay. My next point, I didn't see it in the presentation, and I'm speaking from personal experience here to a certain extent, because I have lived in these sorts of buildings myself in Kingston. And given that you have 5 units, I'm wondering if the building and planning staff are satisfied as to the level of proper insulation between floors of the units. I was in a building that didn't have this, and it eventually had to be upgraded substantially following inspection. So, okay. Now my next 2 points may be covered, by the committee later on, but I don't know that. So I'm just going to say this has gone on for quite a long time, the fact that this hasn't been compliant, and that's been hit by members of the committee. And then we now have a timeline for the resolution over the next few months, starting in the spring to construct and so forth. The plan is there. That's good. What I'm wondering, though, is what might happen if that schedule is not completed on time? Could there be a fine assessed to the landlord on it? And then my final point is on a similar theme. This is not acceptable to me, the fact that this has gone on for this long in a non-compliant situation with some safety shortfalls and so forth. And we're now getting at it. But what I'm wondering is, could similar cases, if there are any that arise, be dealt with more, I would say, stringently by staff and enforcement through a progressive series of fines against the landlord should the non-compliance continue? Thank you.
Great. Any further questions or comments? Seeing none, we'll declare the public. Yes, if you want to go to a microphone and just identify yourself, that would be good.
My name's Jay Patry. I'm the owner of the property. I think I'd just give you guys a little bit of background information on this site. I bought it in 2001 as a power of sale from RBC. When I did buy the property when I was, I guess, 21 or 22 years old, I got a letter from the city of Kingston that said it was compliant for zoning. We bought a 6-plex from RBC, and it's kind of as is, whereas as a power of sale. So my solicitor got a zoning compliance letter from the city of Kingston that said it was compliant. However, on the bottom of the letter that the city issues, it says you cannot rely on this letter for anything. Fast forward 10 years or so, and it became identified that the site wasn't compliant, and it had a shortfall on a couple of things, mostly amenity space at that time. At which point we made an application for a minor variance to have it changed to be compliant. The minor variance committee felt that the amenity space reduction at the time was too much, and then asked us to do a zoning compliance application. We made that application, and for one reason or another, it has taken a long time. think it's both my fault as well as the city's. There's been times where I pushed it, and there's been times where it's just kind of fallen off the radar on both sides. There was some questions with regards to parking. The 3 parking spots, I think, is adequate. I've owned the site for, I guess, 17 years. A couple of years ago, we reviewed all of our leases. At no point did we ever had more than 3 people requiring parking there. Most of the time, it's 1 or 2. I do also own the 2 buildings directly behind it, and they have more than sufficient parking up there as well. So we have an abundance of parking in the area. So I'm not concerned, at least from that side of things. And I think there's a good history that shows that 3 spots is sufficient. With regards to the cellar aspect, the building part that's in question is mostly the rear of the property. That was put up by a previous individual, not myself. And sometime in the mid-90s, they issued a building permit for them, and that included the rooms that are currently in the basement. So it's an 8-foot basement. By all normal living standards, you would have no problem with it if it was in the township. You know, I'm sure some people actually have basements in their own home that kids live in here in this room that are similar. So it's a little bit deficient according to the cellar definition, but it's certainly not one of the situations where you'd find a small little window and most of it below grade. It's just barely deficient. It was issued with a building permit and then by the city in the mid-90s with occupancy in that basement. And I think that's pretty much about it. I'm here to answer any of the questions that people might have, but basically we're just trying to make a situation that I bought 17 years ago compliant, and we are going to have to remove a good portion of the roof on the property and raise it up about 2 inches to make it compliant. So it's not without cost. People are a little upset that they think that I've been doing this forever. I was fined $25,000 in 2010 for having a non-compliant property, even though we didn't know it was compliant, and we had kids in there at the time, so we couldn't exactly evict them, and we made an application to make it compliant immediately upon finding out that there was an issue.
Thank you. Seeing no further public comments, I'll declare this public portion of the meeting over, and we'll go back into committee, and I'm looking for a mover and a shaker for the motion. Thank you, Councillor Chappelle, Councillor Hill. Questions regarding any of the issues or any further questions anybody have or comments? Seeing none, I'll again ask you if you would, I remembered the question I forgot to ask, so.
I recognize you.
Thank you very much. Oh, I apologize. I didn't give you opportunity to answer the one person's questions. So if you care to, that would be great.
Thank you, Mr. Chair, through you. So the first comment was with respect to the idea of off-site parking for this development. Mr. Patry's spoken to his firsthand knowledge of the parking situation on the property. If the recommendation is approved, he's required to construct the 3 parking spaces on the site. In addition to that, he owns property within the area. The zoning bylaw does permit off-site parking within 60 meters of the subject site, so that's an opportunity that he could pursue as of right with the current zoning. In terms of winter safety and the level of insulation within the building, those are 2 considerations that don't really play into the planning review of a development. Can't really comment on those 2 aspects. In terms of the idea around enforcement and going through a progressive series of fines, the way that enforcement is handled must be in compliance with the Planning Act. I will say that I became a development planner in 2014, and with this last term of council, there's been a definite emphasis and attention and direction given to staff to place more importance and attention to enforcement files as well as resources, and so I think that's assisted with bringing this file to the stage this evening, and so it would be great to see that continue, to have that type of eye on complaints that were received from a zoning perspective. And Mr. Dixon also asked about the adherence to the stated schedule of the building works that are required to bring the property into compliance with the code. I'll just maybe defer to Ms. Capner-Hunt as to what avenues we would have as staff to follow up on ensuring that the schedule of works proceeds, because under our planning tools, we really don't have the ability to enforce a certain schedule through the zoning amendment that's being recommended.
Through you, Mr. Chair, it allows us to revoke a permit if they don't commence construction within 6 months of permit issuance, or if they don't substantially complete within a year.
Thank you, and thank you very much for the presentation. So,
You had, didn't you, Councillor
I
Neal,
did.
Mr. Chair?
thank you. That question. I know that there's been full occupancy for almost a decade, even though it's been in non-compliance. Do we have some assurance that there won't be any occupancy during the construction period, and that they will need a building inspection before an occupancy permit is presented at the end of the construction period? If you could respond to that. That's a kind of hybrid. It's part planning question, part building question.
Yeah, through you, Mr. Chair. Yeah, the building permit, now I didn't forget your question. So the occupancy, yeah, so we would ensure that all the construction is completed and all the minimum life safety requirements under the code are completed prior to occupancy, and they wouldn't be able to occupy without the occupancy certificate.
And I appreciate Mr. Patry's response about my concerns about parking, but how both that and the commitment to 5, I believe, internal bike parking locations in the building, and the assurance that there won't be additional parking creeping onto amenity space. How would we go about assuring that is the case? Will that only be complaint driven?
Through you, Mr. Chair, through site plan agreement, we would obviously secure the plans that would show the location of the parking spaces, where the bicycle parking spaces are identified in the property. We do require securities to ensure that those works are completed. And before we can release the securities, we do on-site inspections to ensure that the works were completed in compliance with the site plan agreement.
Yes.
Thank you, and through you, just quickly adding on to Ms. McCormick's response. So beyond the final site plan compliance and the full release of the securities upon 100% completion of works on the property, should there be alteration to the property at any point beyond that, we do mostly have a complaint-driven type of situation for that type of enforcement, but certainly if those matters are brought to our attention, staff will be following up on them.
Great, but there'll be inspection from both a planning perspective and a building perspective at the end of the process.
Correct.
And Mr. Patry motivated to have it completed by the end of August, because that's the beginning of the rental season. So, great. Thank you very much.
I return the chair.
Thank you. Any further comments? Seeing none, I'll call the question. All those in favor? Opposed? Carried. Thank you very much. And thank you, staff, for a very thorough report. We'll move on to our next file, which is the Brownfields Community Improvement Plan Amendment. And that's before us on Sir John A. Macdonald. That's the old prison for women. And we'll go, let the planner introduce the topic, and then we'll go into committee for questions.
So good evening, Mr. Chair, once again, members of Planning Committee, members of the public and staff. As I said, my name's Lindsay Lambert, and I'm a development planner with the Planning Division. Here this evening at this point of the agenda to present the staff recommendation of approval for an application for Brownfields CIP amendment to create a new project area for the site located at 40 Sir John A. Macdonald Boulevard. A statutory public meeting was held on this application on November 15th of this past year. And so the purpose of the application is to create a new project area within the community improvement plan to facilitate a future separate application for financial assistance towards the environmental remediation costs under the Brownfields program. The CIP amendment process is an application under the Planning Act and is similar to an official plan amendment in a lot of respects in terms of its process and statutory requirements. Staff are not in receipt of any other Planning Act applications at this time for the redevelopment of the property. At the bottom of the slide there shows most of the property. It's the former prison for women property at 40 Sir John A. Macdonald Boulevard. It's approximately 3.27 hectares in size, and it has road frontage on Union, Sir John A. Macdonald Boulevard, and King Street West. This is a site photo of the property taken from the Sir John A. Macdonald Boulevard frontage, showing the main former prison building. The property is designated under Part 4 of the Ontario Heritage Act, and the designation bylaw dates back to 2007. In terms of the former prison, it was established in 1934 and was decommissioned in 2000. In 2007, the property was sold by Canada Lands Corporation on behalf of Corrections Canada to Queen's University. In 2018, Queen's sold the property to the current property owner, who's in attendance this evening, Mr. Dornekamp. In terms of the official plan, the property is currently designated institutional, given its past uses, and the applicant is not proposing to change the current land use designation at this time. In terms of zoning, the property is located in the E2 zone, which is a special education and medical zone of zoning bylaw 8499. And again, the applicant's not proposing at this time through this process to amend the existing zoning of the property. So that's the front cover of the current city Brownfields CIP document. And the CIP is a tool to allow municipalities to direct funds and implement policy initiatives towards specifically defined project areas to encourage rehabilitation and to stimulate development. The plan was updated most recently in 2017, including adding a policy prohibiting brownfield financial assistance to properties that have been owned by upper levels of government and properties owned by upper levels of government within the last 10 years. So the subject property was purchased by Queen's in 2007 and is now owned by a private company, and therefore it's considered eligible for the program. This slide shows the 5 existing project areas within the city. One being the old industrial area, the largest area in brown on the map. 1B being Block D, which is a developed site. Area number 2, which is the Williamsville section of the Princess Street corridor. Project Area 3, which is 223 Princess Street. area number 4, which is 700 Gardners Road. And this slide shows the proposed project area for the subject site. There was a council report in June of 2018, and the recommendations within that report were approved, specifically to direct staff to consider the property as a new project area within the CIP document upon receipt of the appropriate application to do so, which is the subject of this evening's recommendation. Secondly, to work with Heritage Kingston to review the existing designation bylaw with the intent of making changes, including the interior attributes. This property has a designation bylaw that protects both attributes on the exterior of the building as well as interior to the building. And that would be in order to support the adaptive reuse of the building and the redevelopment of the property. And then thirdly, to consider the adaptive reuse elements of the project as part of the owner's community benefits contribution that would be required in the future under the Planning Act through a redevelopment application and enabled through Section 37 of the Planning Act. In terms of the official plan, this slide shows Schedule 10, which identifies all of the area within the urban boundary to be within the community improvement plan area. And through the staff report, staff examined section 9.8.5, which establishes 18 criteria for the consideration of a new project area. And the site has to conform to one or more of the criteria. Things that are under that section of the OP consider things like building stock, underutilized land, cultural heritage, presence, infrastructure deficiencies, community and social facilities, off-street parking, traffic circulation, building vacancies, incompatible land uses, streetscapes, visual amenities and points of interest, the need for remediation, energy efficiency of building stock, intensification, and carbon emissions. So in conclusion, through the staff comprehensive report, it is found that the application is consistent with that policy section of the OP. To date, staff have not received any written correspondence on the application. However, at the public meeting in November, the concerns around the built heritage of the property and what is actually applicable in terms of financial assistance in the future should the application be approved. So prior to the public meeting, Council had given direction to staff to re-examine the designation bylaw, and so staff have that direction to work with Heritage Kingston, and that'll be part of a public process to do so. And in terms of the as to whether any of the interior cleanup elements interior to the building would be eligible for financial assistance, staff have confirmed that expenses related to the abatement of designated building materials such as asbestos and lead related to either the demolition or restoration of buildings within approved projects could be considered eligible. In terms of the actual amendment, as part of this application, the amendment of 2 bylaws is required. The first one is 2005-40, which is a bylaw to adopt the Community Improvement Plan, Brownfields Project Areas 1A, 1B, 2, 3, and 4. This is the Schedule A to add the property in terms of the mapping within the plan. And then the other amendment would be just to simply rename the bylaw to include the new project area number. The second bylaw required for amendment through this application is 2005-41, which is a bylaw to designate Brownfields projects areas 1A, 1B, 2, 3, and 4 as community improvement areas. And so this amendment includes a new section within the plan to describe the project area. And then again, the bylaw is renamed to include the project number, area number. So in terms of the staff recommendation, as noted in the staff report, the proposed amendment has the potential to spur numerous wide-ranging benefits for the site, the overall neighborhood of the Portsmouth area, and the city as a whole. And the proposed amendment has been found to be consistent with the PPS, conforms to the city's Brownfields CIP document and the official plan, and therefore staff recommend approval of the application. In terms of next steps, should the application be approved, the property becomes eligible to file an application for funding through the city's Brownfields program, and any future redevelopment of the site would require separate Planning Act applications, and those processes would include statutory opportunities for public review and input. Thank you.
Thank you very much. And I'm assuming that all necessary, are there any necessary contacts on this particular file? There wouldn't be under the CIP, would there? It's only under planning that we need to let people in the immediate area know? Is that accurate?
The staff did consult with the Environment Division. They have reviewed the report and are satisfied with it.
Great, thank you. I will move to the committee and ask if there are any questions or concerns. Yes, Councillor Chappelle.
Mr. Chair, I'm just curious, I'm not Brownfields funding envelope, and I'm curious as to know what sort of monetary value might be in existence.
Yeah, could I ask a staff person to the policy provisions of the CIP?
Through you, Mr. Chair, there's 3 different types of funding identified in the plan. The first one being an initial study grant, which I believe provides for up to $20,000. And then there are also 2 other avenues, being the Brownfields Financial Tax Incentive Program and the Tax Increment-Based Rehabilitation Grant Program. It's hard to kind of indicate how much funding would be available at this time. More needs to be learned about the actual situation on the property, how much something like an RSC would, record of site condition, which is filed through the Ministry of Environment, Conservation and Parks. So there is some more information that would be needed to be learned about the property to decipher how much funding would be awarded.
Yeah, and I'll just add quickly that it originally was a kind of declaring an area or a region, and when we amended that, there was a recognition that there would be right across the city site-specific need for remediation, or we'll never get taxes from those properties. And the result is that when we amended the policy, we included the opportunity for site-specific zone or site-specific granting. Yes, Councillor Hill.
If the, through you, Mr. Chair, is the entire building that's on that property under a heritage designation?
Through you, Mr. Chair, the way that Part 4 designation occurs under the Act is that it applies to the whole real property. It's registered on title to the actual legal description of the property. Within the designation bylaw, which staff could provide to you if you're interested, there are a list of heritage attributes that are protected. This bylaw covers all 3 themes or areas of designation, being the physical design value of the actual buildings on the site, the historical association in terms of the history of the property and its importance to the municipality, the region, and to Canada. And then thirdly, its contextual value as a kind of a landmark within the area.
So my question, I guess, would be, given that, what sort of obligations does the landowner, the current lease owner or title owner, have to maintain that building in sort of good repair and secure it, I guess, and in the intervening period between now and whenever they do apply for a zoning application, I guess, right?
Through you, Mr. Chair, through discussions with the applicant staff, I've learned that there are parts of the building that are not in good repair upon the owner taking ownership of the property. Of course, the building is very important to the site and to the city, and so it's understood that it would be comprehensively, adaptively reused through any future redevelopment of the site. In terms of addressing deficiencies or disrepair on a heritage property, again, it's kind of a driven process.
Thank you, and I mean, this is not to disparage at all the folks that have this. I know they do great work with heritage properties in the city, and I look forward to how creative they're going to get with this piece of property as well. It's just, you know, you worry about the potential for it to be really deteriorate and ensure its security. That's all. Thank you.
Great.
Mr. Chair, if I may add, I failed to mention that in concert with the Planning Act process, a heritage permit process would be required for alterations that affect the heritage attributes of the property, and so those alterations would come before the Heritage Kingston Committee, as well as council for an approved heritage permit before works are undertaken.
Thank you very much. If I can just recommend that that we stay totally focused on the planning implications before us, both the heritage review and at a future date the planning will come back for a public meeting and a comprehensive report with, again, another opportunity for the public to speak to this body, and along with Councillor Doherty and I, we sit on the Heritage Committee, and there'll be a full public meeting with, I'm sure, lots of input at that time as well. So yes, Councillor Kyle.
Thank you, Mr. Chair. Through you, I'm wondering about the nature and extent of the environmental contamination on the site. What do we know now? You mentioned lead and maybe asbestos in the building. Perhaps on the grounds there are other concerns?
Through you, Mr. Chair, I don't have a lot of knowledge on that aspect. I think a lot of it is that it's suspected that there is environmental contamination on the property, given that a historic prison use, there was some industrial elements to that use. And when I mentioned asbestos and lead, those are contaminants that have been identified as being something that could be funded through the program if they're found within the building. Perhaps the property owner may have more information at this point.
Could I just say that this begins that whole process, because the grant that they receive, which is a grant, not a loan, that's when that assessment is done, and it'll be peer reviewed by our staff as well.
Excellent.
I think planners want to correct me if I was.
No, through Mr. Chair, I was going to say exactly what Councillor Neal just spoke to. So the initial study grant, the purpose of that up to $20,000 is to allow for the owner of the property to complete the environmental site assessments that would be required to determine the amount of contamination. So it wouldn't be until those studies are completed on the property that we would actually know the full extent of the contamination that exists on the property.
Great. Thank you, Councillor Hutchison.
Thank you, Mr. Chair. I have a lead up to a question and an answer to, and perhaps the director, Ms. Agnew, knows this answer, And, but I believe the upper amount of money allowable under the program is 10 million. And I think that was applied in the Block D situation. But I think it was also because we have done so much of that, we passed a revised policy, and I'm not quite sure how that all came out in the end.
Thank you, and through you. So I don't know exactly how much was approved for Block D. That predated my time with the city. I do know that relative to what can be granted, it can exceed the remediation costs on the property. So it's a sliding scale depending on a number of factors. There's a lot of analysis that's done from staff looking at what the extent of contamination is. It also factors in the purchase price of the property, and if there was discounting of the purchase price relative to known contaminants or contamination on the property. So there's a variety of things that would be reviewed in detail through the environment group to determine what the appropriate amount of funding is, but it certainly can exceed what the overall amount or the cost would be of the contamination. So because we do have a number of brownfield sites throughout the city, we do try to look at how to reasonably share costs so that not all of the funding that can be allocated by the city in a particular window of time goes to one property. There's the sense of trying to distribute it to make sure that we're looking at equal opportunity for remediation in the areas that have been identified through our official plan.
Thank you. So I'm pretty sure about that thing. And the one on the innate building was around 1.2 or 4 million. And so as Ms. Agnew said, it slides up and down according to what they can prove they need. And now we did put certain, and this was my question. I've gone looking at this one, but it seemed to me that I think the question's already asked, what is the extent of this and what are we likely exposed to? It didn't seem to me it would be anything like Block D, but I'll just drop that question because it'll come out in the wash anyway. And so my question is more focused on, because I can't remember how the policy was revised, but it was definitely done to restrict the city's exposure in terms of tax liability. Like, we had done so much, we couldn't really afford to do much more. I talked to the CAO about that 3 years ago, and I just wondered, here we are in a situation where we're being asked to do this, and I'm inclined to do it, but I'm not quite sure what the context is in terms of our liability exposure relative to all the other brownfields. It's a tax rebate program that we've got out there. So we're not getting taxes, but we're actually giving them back when we actually have already supplied the infrastructure. So it's a bit of a risk for the city. It's paid off handsomely. I'm not arguing against it. I think it's great, but I wonder if Ms. Agnew has anything to say about that.
Thank you, and through you. So you're correct that relative to the city's budget and the envelopes that are established related to this program and the tax rebate particularly and how that's paid off over a period of time, certainly there are upper limits to what the city can sustain at any given time, knowing how it factors into our overall budget. Related to this piece in particular, because we're just establishing the first stage or the first criteria for this property to even be considered. I don't know what the specific numbers are, but certainly as part of the step 2, which would be the detailed application and where all the information comes in and looking at the financial analysis piece, you'd see a lot of detailed breakdown of what the costing is, and certainly it wouldn't be anything that would exceed the envelope that the city could afford relative to its overall payback period.
Thank you. So my understanding of that is say, yes, we think it's a good idea based on the report, and then it goes to council to do the same, but that doesn't say they're going to get it. That has to be, well, partly analyzed and partly negotiated relative to what you just said about our potential liability
That's correct. Thank you. And through you, this is the first stage. So our official plan, in order for people to be able to apply for consideration to the program, have to be within a community improvement project area as defined in our official plan. So that's really what this application, it sets the foundation to give them permissions to apply to the program. So you'll see as part of subsequent applications that come forward to the city and reviewed and peer reviewed by staff, that detailed information. Tonight is just saying this is a site that we want to have consideration to apply to the program, not necessarily to approve it 100% or to approve a certain amount. It's to give that initial nod so that there can be an application. But relative to that, it's suggesting from an overall policy perspective that we're recognizing this is a very important site within the city. It's in a central area. It has a beautiful Part 4 building on it. It has historic views associated and a very long, important part of our cultural history. So it's really about the city recognizing that it's an extremely challenging site to adaptively reuse and redevelop, and that we're therefore interested in looking at ways to potentially work with partnership opportunities with the developer to see what tools the city has to help bring that forward to a project.
Thank you. This last question. I was reading things that you put on this property, and I think it said something about residential. So does that include like condos? And are there height restrictions because of the prison? This is a secondary question. The prison and the prison of women, you know, the heritage aspects of it, and massing and all that. Like, do those restrictions apply?
So thank you, and through you, certainly there are some zoning permissions on the property right now that aren't very conducive to adaptive reuse because they're really more educational based, institutional based. So as part of being able to redevelop the property owners, which are here with us this evening, will have to go through additional Planning Act processes to amend the official plan and the zoning bylaws specifically. As part of that, there would be the detailed studies that would also include a heritage impact statement that would be looking at the rationalization for whatever they're planning to do through a redevelopment concept relative to the sensitivity of the heritage building on the property, how important things are going to be preserved through that process, and the height limit, the density, all those types of things will be subject to separate applications that will come forward through Planning Committee at a future date once they're filed.
Thank you. Add a little clarity to the whole issue of brownfields. Is it right that the only direct money that the city gives to a developer in a brownfield situation is the grant for doing the initial study? And everything else comes about through, and I think this may be building fee, both development fees, but also through taxation. We allow a phase-in of those things, so it isn't actually costing taxpayers money, but in the end, we get taxation we wouldn't otherwise get on the property. And so it's a plus to taxpayers. Is that an accurate statement?
That's correct.
Thank you. I love it when people say that. Thank you very much. So, any further questions or comments? Seeing none, I will open it up for public comment, but I just want to really, really stress, we have all just sat through a meeting till midnight 2 nights ago. So I'm going to be really strict about us only speaking to what's before us, which is a recommendation solely to do with a brownfield designation. Heritage, there will be a full public meeting at Heritage. Planning, there'll be 2 opportunities at planning to speak to this. So, but any member of the public is welcome to speak on this particular issue.
Good evening, Mr. Chair, committee members. My name is George Karen. I live at 796 Unity Road. I think I know a little bit about the prison for women. Since in 1975, I came as the deputy warden for 4 years. And then from 79 to almost 88, I was the warden. Generally, I would support the applicant's totem consultant's proposal to amend the city's Brownfield CIP to add the prison for women property as a new project area. Upon approval, the developer can apply for financial assistance towards environmental remediations. It is acknowledged that the developer, ABDA, recognized that the environment cleanup of environmental contamination will be required for the site and existing building. Please note that a sizable amount of funds should be allocated to the development to remove extensive mold, asbestos, old electric wires, lead, and other toxins from the interior of the building. Between KP and the prison for women, there's tunnels under there with lots of old pipes and asbestos. Before mold can be removed from the building, a heating system must be turned on. At this time, I must remind committee members that the Prison for Women building has a heritage designation, which we talked about earlier, they did, that not only protects the exterior of the prison building, but it also includes protection of a number of interior attributes which were specific to a prison use. The said property has a status as a recognized federal heritage building since '89.
Excuse me, I believe you're wandering into the heritage discussion rather than focusing on what's before us.
Okay,
So please speak to the Brownfield designation, what you're speaking to. I would love to hear at the Heritage Committee, which I sit on as well, but it has no impact on what we're dealing with tonight. So, thank you.
I hope and trust the councillor members will learn and respect historians and heritage elders that support the Prison for Women cell blocks and locking mechanisms, be totally preserved as evidence reflecting how Canada imprisoned female inmates from 1934 to 2000. Prisons are not kind places, but there are supporters that want to return the prison for public tours. Alcatraz, Robben Island, Kingston Pen, Devil's Islands, all these prisons. All efforts must be made to protect historical buildings and the prison. One of the things that I noticed...
Again, I apologize for
I just heard you.
interrupting,
I'll just finish this up if I
but
may.
let's not talk about heritage.
Well,
Okay?
I got
That's
this
why we have a heritage
document
committee.
just tonight, and I noticed about community benefits. Preservation of the heritage building and fence are not considered a benefit. This document, if I may, but basically says that ABDA will indicate that it's willing to work with the city to ensure that the interior heritage attributes are not functional in the adaptive use of the building.
I'm going to have to rule
Okay.
you out of order because we have a heritage committee, and I really look forward to you coming and sharing all of that information with us at Heritage. But we need to focus on the recommendation here, which is a Brownfields designation. You'll have ample public time at Heritage and again at planning, two occasions at planning to talk about whenever that proposal comes forward. So,
In summary, the bottom line would be, if there's money allocated for the brownfield, I would hope that it would go towards the interior of the prison. Thank you.
thank you. So, any further public comment? Seeing none, I'll turn to planning, to the planner to address the concerns related to this file.
Thank you, Mr. Chair. Through you, Staff have confirmed through the review of the application when the question came up at the public meeting as to whether the interior contamination elements could be considered as part of the funding, and the answer to that was yes. And so that consideration can certainly be folded into the future evaluation, identification of contamination on the property.
Thank you very much. I will declare the public portion of this meeting closed, and I will open it up for a mover and a seconder for the recommendation. Yes, Councillor Chappelle, seconded by Councillor Hutchison. Any further questions or comments related to the recommendation? Seeing none, I will call the question. All those in favor? Carried. Thank you very much. We'll move on to our final issue tonight, which is the discussion regarding commencing planning committee meetings at 6 p.m. I'll preface this with the reality that there are signs out there for public meeting notices that say the public meetings are at 6:30. And for those to all get kind of worked through the system, I believe will take us to later in March, if I understand. So if we do decide to alter this 6:30 time to 6 o'clock, it wouldn't, by necessity, it wouldn't take place until after. I've also, I'll welcome an opportunity for staff to weigh in as well. I know that this affects your lives as well as ours. So, yes, Mr. Chappelle.
Mr. Chair, I had the pleasure of meeting with members of the planning and committee today, and my conversation extended beyond the time I thought it was permitted, and I'm grateful for the opportunity to have addressed a number of concerns. And that brought me to thinking that where we currently have an issue where we want to go home, have dinner with our families, that originally I thought 6 o'clock might be a good idea, but I think 6:30 is probably more appropriate, just based on the complexity of some of the issues we deal with, a little more time than we need to reflect on them. So I would support just maintaining the time frame as it is currently posted at 6:30.
And maintaining it as alternating Thursdays, I presume. Yeah. Yes, Councillor Hutchison.
Well, that sounded good to me, especially since you've talked to staff. And I know a couple of them got young kids or going to have, so that sounds good. And one of the reasons why it's 6:30. I just want to ask the clerk. I meant to go through this myself, and I just didn't get to it. On the alternate Thursdays, this just happens to be the way it's unfolding now, or will it always be? Will planning always be in the same week as a city council meeting? Because I personally think that's kind of punishing, in terms of the amount of stuff you have to cover, and do a good job of it as well. So could you straighten me out on, because I always thought it was the second and fourth week for planning, and
so through you, Mr. Chair, for at least, I think the last decade, the planning committee has met on the first and third weeks of the month, which is also coincides with the council meetings. The Administrative Policies Committee and the EITP Committee meet during the second week on Tuesday and Thursday, and then finally the ARC Committee meets on the fourth Thursday. So essentially there's 4 standing committees set aside on Thursday, and the only deviation to that schedule is EITP. I would caution that to switch the weeks around for planning committee to avoid the doubling up of council would take significant lead time, And that's probably something that we can't commit to tonight or should go down that road just right now.
My follow-up question is to my fellow councillor, Councillor Sanic, who's been on this committee, I think, from the whole time we've both been on council. So I'm just wondering how you've found it. Like, when someone like myself brings it up, do you find like, yeah, I don't like that, or does it just work okay? Because I've never been on planning, I've been on all the others, but not this one. And I just want to know if it's going to work over time.
Through you, Mr. Chair, I'd rather have a week and then a softer week and then another killer week. And that's the same way for budget. Why I moved a motion back in, I don't know, 2000, a long time ago, that we have our budget meetings all in a row, right? Like just do it and, you know, go through the hardship and then it's better.
Well, I don't know. I mean, she just admitted it was killing. So I'm not quite sure what to do with that information. But the clerks tend to know their business about this sort of thing quite well. And so I recommend no changes based on what Councillor Chappelle said and Councillor Sanic said. I just thought it would be good to move, but I can see why the clerk would be just like turning to jelly inside at that thought. So, and maybe staff too, because they've got their whole lives circled around these meetings, if my experience in these things is anything. So, okay, I give up. Okay,
Councillor
that's fine.
Just for everyone's benefit as well too, by having the planning meeting the same week as council, there allows opportunity for files to reach the next planning committee meeting, the next council meeting. So if you were to adjust the schedule by meeting on Thursday, then the council agenda is already out and that type of thing. So it gets complicated pretty quick.
And any further questions, comments? I will invite staff to make a comment if you wish. I guarantee it will not be a career move, whichever decision, whichever preference you might have. But so go ahead.
Thank you. Three, we serve at the pleasure of council, so whatever decision you make is obviously we're happy with. We're used to 6:30. We would be fine either way. Certainly the majority of us do have families and young children and try to see them in between sometimes, so a little extra time is nice. The other consideration is as we're working through the recommendation about incorporating the public open house components of complex applications, we are trying to align those on the same night as planning committee for ease of you as well, because you'd be in the building, and for staff with coordination and overtime and all of those pieces. So having a little bit of extra time so that we could have a full hour for an open house is helpful. But again, we're here to serve at your direction. Whatever the committee's decision is, we're fine with that.
Thank you very much for that very politic answer. I appreciate it. So I will say one staff member said it would be nice to get home to tuck my kids in. So that I think is a good reason to at least consider this. I don't see a particular motion in front of us. This direction was for discussion. And since we're talking about late March before it can be implemented anyway, I'm wondering if it might be procedurally okay for the clerk to bring a motion forward and it can give us two options to choose from, or it could be a motion that recommended 6 o'clock, and if it fails, you're always allowed to bring up the second. You want to do it tonight? Okay. Okay, so we should do it tonight. So if there's a mover? Yes.
If we just leave, doesn't it just die?
There is no need
For a motion.
to discuss this matter further. If someone would like to move a motion tonight, would be an appropriate time.
Doesn't sound like there's a reason to discuss it. If it just left, it dies.
Yeah, so if we could have a mover and a seconder to move it to 6 o'clock, and then we'll open it up for further
what I was just
discussion,
saying-
and we'll just
What I
have a
was
quick
just saying
vote.
is we don't have to do that.
Pardon me?
We don't have to do that. You just drop it, and it stays at 6:30. There's no need for a motion. It's a formality we don't need.
You're right, if we don't have a motion, it'll be status quo. And is that what council wishes? Or the committee wishes? Okay. That's unfortunate, but I will not vacate the chair to bring a motion forward. Thank you very much. There are no further motions. There's any notices of motion? Seeing none. Other business and correspondence. We did receive a letter in correspondence here. Any comments? Seeing none. Under other business, I just wanted to point out the provincial government yesterday blinked and declared that they won't be going forward with Bill 66. We have a motion coming up, and I believe that there's a report coming forward from our planning department, and the only question I think we need answered is with what's left in that bill, with the removal of what they've removed, will it have an impact on our planning process? So, yes.
Through you, Mayor, planning staff will be bringing a report forward to the February 6th City Council meeting where we can have a fulsome discussion about it. We have recently updated the report to reflect the tweets from the Minister of Municipal Affairs that suggests that the second reading of the bill will remove the proposed changes to the Planning Act. At this time, our report does focus on our feedback on the initial reading of the bill, but we certainly hope that the second reading of the bill will implement the changes that we're anticipating.
And it's my understanding they'll also be removing the Safe Water, the impact on the Safe Water Act. Is that accurate? Is that your understanding?
Through you, Mr. Chair, yes, that's my understanding, but it's certainly, we're kind of speculating because we don't actually have the details about what the proposed changes are to that bill. We only have the first reading since the second reading won't be until later in February.
Thank you. And I believe you had your hand up? No? So that probably, that motion is already on the agenda as a notice of motion. And it'll be up to the mover and the seconder, who is me, to choose whether we want to withdraw it in its entirety or we want to redraft it to reflect the report that planning is bringing forward. Okay, that was just by way of information. Date and time of our next meeting, February 7th. And if there's no further comments, motion to adjourn. Take your pick. Pick of the litter. Everybody raised their hand. So thank you very much.